A very good evening to everyone who have joined us today to be a part of this imperative lecture series. I am Sankirtana. I will be your moderator for today. I take immense pleasure in welcoming all the esteemed members of the KSBC Law Academy, distinguished advocates and lawyers, academic scholars, students, and everyone else who have joined us this evening to be a part of this imperative lecture series. Today is the last and final day of the 4-day long lecture series. We request all the participants to remain on mute throughout the duration of the session, kindly requesting all of the participants to send across your question in the chat box. After the lecture is over, some of the selected questions will be posed to our esteemed speaker. Please utilize this opportunity. Uh, Venkata Sudarshan sir, now the forum is open to you. Sir, you're on mute.
Is it okay? Am I audible?
Yes, sir.
Okay. So today is the last day in this series of 4 days. Respected Chairman of the Karnataka State Bar Council and also all the respected members of the esteemed institution. Shri Gautam Chen sir, the President of the Law Academy, Karnataka State Bar Council, and all the learned viewers who are in this platform. I have been given this opportunity of discussing about this Bharatiya Nagarik Suraksha Sanhita in brief over a period of 4 days, for which I express my deep gratitude and sincere thanks to Karnataka State Bar Council and also to the President of the Law Academy, Karnataka State Bar Council. Thank you very much, sir. Now we will move on to the next topic, that is complaints to magistrates, which is in chapter 16 of BNSS and chapter 15 of CRPC. Section 223 to 226 BNSS is equal to section 200 to 204 of the Criminal Procedure Code. This is a chapter with which all of us are familiar, that is with regard to the presentation of a private complaint before the magistrate. Section 200 CRPC, the equivalent of which is section 223 BNSS, says that a magistrate having jurisdiction to take cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. In the first session itself, we have seen the definition of the word complaint. Complaint means any allegation made either orally or in writing to a magistrate with a view of he taking action against a person known or unknown for the offence committed. So, here we are getting the word complaint for the first time in this BNSS and also CRPC. So, complaint means it is an allegation made before the magistrate. It could be either oral or in writing. Then the magistrate before whom such complaint is filed, if he wants to take cognizance of the offence, he must proceed to examine the complainant and witnesses, if any, and record the substance of such statement in writing. And such statement will have to be signed by the complainant and section 1 of section 223, which is equal to section 200 subsection 1 also says there is no change and it remains as it is. So one of the important aspects that has to be considered here is, for the benefit of the freshers I am talking about, the statement that is going to be recorded of the complainant and the witnesses under subsection 1 of section 223 is not the evidence, is not an evidence as contemplated under the Evidence Act. It is only a statement which we call it as a sworn statement or verified statement. So it is not a evidence. Evidence means examination in chief, cross-examination and re-examination, if any. All put together will constitute what is called as evidence. But this cannot be considered as an evidence. It is only a verified statement or a sworn statement of the complainant and witnesses. Now, there is one change that has been made in BNSS to this section. That is the first proviso to subsection 1, which reads that provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. This is for the first time that this proviso has been introduced in the procedural code. This provision means that before proceeding to take cognizance, the magistrate will have to give opportunity to the accused to have his say, and the magistrate must hear him before proceeding to take cognizance. According to my limited knowledge, earlier, when a complaint is filed under section 200 CRPC, the magistrate had two options. Either he can refer the matter to the police for investigation under section 156(3) CRPC, or he can proceed to examine the complainant and witnesses and then decide whether to take cognizance or not on the basis of the materials which are available. But now, because of the provisions of section 173(4), which I have read yesterday, wherein if a police officer refuses to file a complaint, receive the information given by a person relating to the commission of a cognizable offence, then the aggrieved person can approach the superintendent of police by sending that information which is in writing under RPAD to the jurisdictional superintendent of police. And even if that superintendent of police does not take any action, then a copy of that application has to be filed before the magistrate under subsection 4 of section 173, requesting the magistrate to direct the police to investigate into the matter. So that part of directing the police to investigate into the matter has been taken care of under section 173(4) of this BNSS. Therefore, according to me, under section 223, the only option that is left to the magistrate when a complaint is filed under section 223 is to record the statement of the complainant and witness and then decide whether materials are there to take cognizance or not. Because the question of referring the matter to the police may not arise at this stage, since there is already a provision in the form of subsection 4 of section 173. Therefore, perhaps this first proviso has been added to say that before the magistrate proceed to take cognizance, an opportunity will have to be given to the accused of hearing. So this is what I can understand from this new proviso which has been added to section 223 subsection 1. Now, there is one more addition made. The second proviso says that when the complaint that is presented before the magistrate is by a public servant, and when that complaint is in respect of an act which was said to have been done by a person, then a public servant acting or purporting to act in discharge of his official duties, our court has made the complaint, and if the magistrate makes over the inquiry, makes over the case for inquiry or trial, then examination of the complainant and witnesses is not necessary. That was there in section 200 also, and that is there in section 223 also. That is, when a public servant files a complaint in writing to the magistrate, then magistrate need not examine. The best example that we can give here is a complaint filed by a factory inspector, a complaint filed by a labor inspector, a complaint filed by a person competent to file the complaint under any of the other laws. So these are the complaints which are filed by the public servant in respect of the acts which were done by the accused which was investigated and found by the public servant, and in respect of such complaints, the examination of the complainant and witnesses is not necessary. This exemption has been given according to me for the reason that a public servant is supposed to have been discharging his duty in accordance with the law, that is in accordance with the rights and liabilities that are given to him under the law, and therefore there is no need to examine the complainant again on oath by recording a sworn statement. That appears to be the purpose. There is one more addition newly added to section 223, that is by way of subsection 2, which was not there in the CRPC under section 200. What is it? A magistrate shall not take cognizance on a complaint against a public servant. What I have told earlier is a complaint filed by a public servant. Now what subsection 2 says is a complaint filed against a public servant. A magistrate shall not take cognizance on a complaint against a public servant for any offence alleged to have been committed in the course of discharge of his official duty. Let us say, for example, that there is an offence committed by a public servant by discharging his official duties. For that, a private complaint is filed against him. Then what is the duty of the magistrate? It is stated in subsection 2 that in such cases, cognizance cannot be taken by a magistrate unless he follows clause A and clause B, complies with that as mentioned in subsection 2 of section 223. What is that clause A and clause B? Clause A says, such public servant is given an opportunity to make assertions as to the situation that led to the incident so alleged. That means, when a complaint is filed against a public servant for any act which amounts to an offence in discharge of his official duties, then it is the duty of the magistrate to call upon that public servant to offer his explanation or offer his say as to the situation and that the situation that has a complainant amounts to an offence. So a public servant has to be given an opportunity before taking cognizance. Number 1. Clause B. A report containing the facts and circumstances of the incident from the officer superior to such public servant. So magistrate will have to call for a report from the immediate official superior of the public servant against whom the complaint is filed. For example, if a complaint is filed against a tahsildar, a report will have to be called for from the assistant commissioner or the deputy commissioner. For example, I am telling. To understand clause B of section 2, subsection 2 of section 223 properly. So these are the two additions, one by way of a proviso, another by way of subsection 2 to section 223 of in chapter 16. Then, so far as section 224 is concerned, (224), 225 and 226 is concerned, there is no change. All those the contents of section 201 to 203 has been incorporated in BNSS, which is in the form of section 224 to section 226. So I'm not going to deal upon those things now because there is no amendment. Then we have chapter 17, commencement of the proceedings before the magistrate. So once the magistrate decides to decides to take cognizance either on a police report or on a complaint, the next stage is issuance of process. So the magistrate will have to decide whether the process should be in the form of summons or it should be in the form of a warrant. So that is what section 204 of CRPC says, which is equivalent to section 227. There is no change except a small addition by means of a proviso that summons or warrants may also be issued through electronic means. So except that addition, there is no change in section 227 CRPC. And rest of the content of the section is as it is, which is found in section 204 of the CRPC. Then, insofar as section 228 is concerned, magistrate may dispense with the personal attendance of the accused. In that section also, there is no change and it has remained unaltered in the form of section 228. Then section 229, special summons in case of petty offences. First, let us understand what do we mean by this section. Supposing a particular offence is punishable with fine only, then the usual procedure is a court will have to issue summons to the accused. Accused will have to appear. And if he pleads guilty, he will be directed to pay the fine. Fine will be the punishment. So he will pay the fine and go away. This causes actually a lot of inconvenience because the only punishment is the fine. For the purpose of payment of fine, the accused will have to come all the way from the place where he is, leaving all his work and spending so much of time and waiting in the court hall and all those things. In order to avoid such inconveniences which may cause to the accused who are ready to plead guilty, of the offense, this section 206 of CRPC, which is equivalent to section 229 of the BLSS, has been incorporated. According to that, what the court will do is, the court will issue summons to the accused, and in that summons it will be mentioned the fine amount that the accused has to pay in the event of he pleading guilty. So if the accused is ready to plead guilty, he must record that plea of guilty in writing and send it to the magistrate court along with the fine amount that has to be paid. So once the fine amount and the plea of guilt in writing is received by the court will take it as an acceptance of the guilt by the accused and collect that fine and remit it to the concerned account, government account. So thereby, much of inconvenience which may be caused to the accused otherwise by physical presence can be avoided. So this is the purpose of issuing a special summons in case of petty offences. Now, what is the change that has taken place? The only change that has taken place is under CRPC, petty offence means all those offences where the fine is less than 1,000 rupees. Now that has been enhanced to 5,000 rupees. And it is also stated that petty offence does not mean an offence under the Motor Vehicles Act. So this is so far as section 229 BNSS with the equivalent provision of section 206 of the Criminal Procedure Code. Then we will move on to section 230. Supply to the accused the copy of the police report and other documents, which is equivalent to section 207 CRPC. Supplying of documents, that is the charge sheet and other copies to the accused, is mandatory, particularly in a warrant trial, particularly in a sessions trial. So that compliance will have to be made by the magistrate before proceeding further. Therefore, this section is very important from the point of view of the accused. In this section, the only change that has been made is that the documents will have to be made available to the accused who has appeared before the court are produced before the court within 14 days. Earlier, there was no time limit, but now 14 days is mentioned here. Of course, general practice is, since I have also served as a judicial officer for more than 28, for about 28 years, normally in a warrant trial proceedings or in a sessions trial proceedings, on the very first day itself, the copies of the charge sheet and all the documents will be supplied to the accused, and his signature will be taken on the or in the order sheet for having acknowledged the same, receipt of the same. But anyway, there is a provision which now gives time to the court about 14 days, within which the court will have to furnish the charge sheet and the charge sheet copy and all other documents to the accused from the date of his appearance before the court or production before the court. That is another change that has been brought in section 230 BNSS, which is equal to section 207 of the Code of Criminal Procedure. Then, section 209 CRPC is the section which gave power to the magistrate to commit the case to the sessions court. It is filed in respect of the offences, which are offences which are triable by the sessions court. I have already discussed about it when discussing on section 193 of the Criminal Procedure Code. Equivalent section I have also stated in BNSS that the sessions court will not get jurisdiction to try the case unless it is committed by the magistrate. So section 232 BNSS with equivalent provision section 209 CRPC is the provision which deals with the power of a magistrate to commit the case. In this case, in this particular section, there are two additions that have been made in BNSS. What is it? Number one, the section content remains as it is. There is no change. The first proviso, proceedings under this section shall be completed within a period of 90 days from the date of taking cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days for the reasons to be recorded in writing. There were cases, of course, where the cases were pending before the magistrate without being committed for quite a long time. In order to overcome such inconveniences to the parties and also to the prosecution, this proviso has been added wherein it says that within a period of 90 days from the date of taking cognizance, the process of committal should be completed. If for any reason the committal proceedings could not be completed within 90 days, the magistrate can have another 90 days, but for such extension of another 90 days, he has to record the reasons. So this is the first proviso to section 232, wherein this change has been effected, which is not found in section 209 CRPC. Then the second change is the second proviso provided further that any application filed before the magistrate by the accused or the victim or any person authorized by such person, that is victim, in cases triable by the Court of Sessions shall be forwarded to the Court of Sessions with the committal of the case. There may be certain provisions under which either the accused or the victim will be making an application before this committal court. And committal court will have no power to dispose of such application or applications. So therefore, it is the duty of the magistrate to send all those applications also to the sessions court along with the records while committing the case. So these are the two new provisions which have been added to new section 232 of the BNSS, which were not there in section 209 CRPC. Then section 233, which speaks of a procedure to be followed when there is a complaint case and the police investigation in respect of the same. There is no change in that, and it remains as it is. and the equivalent provision in CRPC is section 210. And the provision in new provision in BNSS is section 233. There is no substantial change in chapter 18 with regard to the charge, framing of charges. Then we will move on to chapter 19 of BNSS, which deals with trial before a court of sessions. At the cost of repetition, I am telling that the trial before the court of session commences only after the case is committed by the magistrate, number one. Number two, after the case is committed to the sessions court by the magistrate, the sessions court will have to secure the accused persons before it. And then the other proceedings as contemplated in this chapter, that is chapter 19, trial before the court of sessions commences. In this chapter 19 of BNSS, which is from section 225 to section 237. No, it must be 235. 1 minute, please. Yes, correct. Section 225 to section 237 of CRPC is equal to section 248 to section 260 BNSS, which deals with trial before sessions court. There is some change or amendment or additions made in this particular chapter. What are they? Number one, when the accused appears or is brought before the court in pursuance of a commitment of the case under section 232, that is 209 CRPC, that remains as it is. There is no change up to this. Or under any other law, any other law for the time being in force. So this is an addition. Or under any other law for the time being in force is an addition in section 249 BNSS, which is equal to section 226 in CRPC. Then, so far as the discharging of the accused is concerned, discharge of the accused takes place before framing charge. In CRPC, under the corresponding provision, that is section 227, it was only mentioned that if upon consideration of the record of the case and the document submitted therewith, and after hearing the submissions of the accused and the prosecution, the judge considers that there is no sufficient ground to proceed, he can discharge the accused. That is what found in corresponding section in CRPC, that is section 227. But now an addition has been made even before the commencement of this section, which says in the form of subsection 1, what is found in CRPC has been retained as subsection 2, and subsection 1 is an addition. What does it say? The accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under section 232. So here is a situation where the accused can make an application pleading for discharge within a period of 60 days from the date of commitment. So this is a new addition that has been made to section 250. Sorry, in section 200 subsection, by way of subsection 1 of section 250. Sorry, 249. Then coming to section 250, sorry, 250. So 60 days time is given. And section 251 BNSS, there is an addition which deals with framing of charge. Section 251 BNSS deals with framing of charge, which is equivalent to Section 228 of the CRPC. Here, there is one subsection which has been added. Since Section 251, subsection 1 CRPC is a replica of subsection 1 of Section 228. Now, B is added to say that if the offence is exclusively triable by the Court of Sessions, the Sessions Judge shall frame charge in writing against the accused within a period of 60 days from the first date of hearing on charge. What does it mean? After furnishing, copies will be furnished in the committal court itself. Case is committed to the Sessions Court. Sessions Court secures the accused before the court. Then the next stage is to hear before charge. So from that date, within 60 days, the session judge should complete this process of framing charge. Why I am telling all this is one of the objective of bringing this BNSS. In the introductory note, about the objects and reasons it is stated. There is timeline fixed, not only for during investigation, but also during trial. So these are some of the sections which I have brought to your notice on all the previous 3 days and also today, wherein the number of days has been fixed within which the court will have to act. Then there is another change, subsection 2 to section 251, where the judge frames any charge under clause B of subsection 1. The charge shall be read over and explained to the accused present, either physically or through audio, video, electronic means. And the accused shall be asked whether he pleads guilty of the offence charged or claimed to be tried. So this addition that has been made to subsection 2 gives power to the court to record the charge even through audio, video, electronic means, which was not found in CRPC. This is another change that has been brought in this section 251, that is on the topic of framing of charge. Then coming to section 254, that is evidence for prosecution. On the date so fixed, the judge shall proceed to take all evidence, etc., etc. That is same as in CRPC subsection 1. There is a proviso which has been added to say that the evidence of a witness under subsection 1 may be recorded by audio, video, electronic means. This is another addition that has been made to section 254, which was not there in CRPC. Then, section 258. Section 258 speaks of delivery of judgment of acquittal or conviction. Here, under subsection 1 of BNSS, after hearing the arguments and points of law, if any, the judge shall give judgment in case as soon as possible within a period of 30 days from the date of completion of the arguments, which may be extended to a period of 45 days for the reasons to be recorded in writing. Now, this time limit that is now introduced in the BNSS was not there in CRPC. In CRPC, there was no time limit that was fixed. And now in BNSS, they say that after conclusion of the arguments, the judgment will have to be delivered within 30 days from the date of the completion of the argument. And for the reasons to be recorded, if it could not be delivered within 30 days, for the reasons to be recorded, the judgment must be delivered within 45 days from the date of completion of the arguments. So this is so far as the changes that have been brought in a trial of cases before the Sessions Court. Now we will move on to Chapter 20. Chapter 20 deals with Trial of warrant cases by magistrates. What is a warrant case? I have already explained. What is a summons case also? I have already explained. Anyway, to recapitulate or to memorize those, I'm once again telling that a summons case is one where the offense is punishable up to 2 years of imprisonment. A warrant case is one which is punishable above 2 years. A warrant case is one which is punishable with death or life imprisonment or imprisonment of any term exceeding 2 years. So all cases where the offense punishable is more than 2 years, it shall be considered as a warrant case, and whatever the procedure that is prescribed in chapter 20 of CRPS or BNSS will have to be followed. And the equivalent chapter in CRPC is chapter 19. So 261 to section 273 BNSS is equal to section 238 to section 250 CRPC. Now here there are two classifications found in CRPC also, and the same is found in BNSS. Number one is cases instituted on police report. Part A. Part B, cases instituted otherwise than on police report. To put it in a simple manner, Part A deals with the charge sheets filed by the police against the accused, and Part B deals with the cases registered on a private complaint after the magistrate taking cognizance. So that is how we will have to distinguish this. Insofar as the cases instituted on police report is concerned, it is from section 261 to section 266. In this chapter, section 262 is section 262 BNS, equivalent of which is section 239 of the CRPC. In section 239 CRPC, it was mentioned that if upon considering the police report and the documents sent with it under section 193, that is charge sheet, and making such examination if any of the accused, either physically or through audio electronic means, this is an addition, as magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, if the magistrate considers that the charge against the accused to be groundless, he shall discharge the accused and record the reason for so doing. What does it mean? That means in a warrant trial, when the accused appears before the court, it is the duty of the court to first see that the copies of the charge sheet and all other documents are served upon him. And an acknowledgement is obtained to that effect in the order sheet. Number one. Thereafter, the matter will have to be heard before charge. That is, court will have to consider whether the charge should be, whether the charge should be framed or not. Earlier, this was the distinction between a summons trial case and a warrant trial case. Earlier, in a summons trial case, there was no stage for hearing before charge. Now that is there, we will come to that later. In a warrant trial case, earlier also that stage was there, and now also there is a stage. That stage is hearing before charge. So, CRPC, the content of section 239 CRPC, which is in the form of subsection 2 of section 262 BNS, is the same, except hearing accused even through audio, video, electronic means. So after considering the materials before the court, that is the charge sheet and other documents, and after hearing the accused and the prosecution, if the court is of the opinion that the charges leveled against the accused are groundless or is groundless, then the accused shall discharge, the court shall discharge the accused. But when the court wants to discharge the accused, the court has to record the reasons for that. For framing charge, reasons may not be required. But if the court wants to discharge the accused and release him, then the reasons will have to be recorded. That is the mandate of subsection 2 of section 262 PNSS. Now, what is the addition that has been made? As has been made in a trial before sessions court, here also, by way of subsection 1 to section 262, it is stated that the accused may prefer an application for discharge within a period of 60 days from the date of supply of copies of documents and under section 230. So, the accused has to make an application before the court seeking discharge within a period of 60 days from the date on which the copies of the documents have been supplied to him. This is one addition that has been made to section 262, that is equivalent to section 239, that is by way of subsection 1, which was not there in section 239. Then, section 263, framing of charge. So if the court comes to the conclusion that the accused cannot be discharged and there is sufficient material to proceed against the accused by framing charge, then the court will have to frame the charge. Earlier, there was no time limit prescribed for the court within which the charge has to be framed. And now, under the new law, that is section 263, it says that the magistrate shall frame the charge within a period of 60 days from the date of the first hearing on charge. That is, when the case is posted for hearing before charge, for the first time, after serving the copies of the documents and other charge sheet and documents on the accused, from that date, within 60 days, it will have to be heard. If accused has to discharge, he should be discharged. If not discharged, charge will have to be framed. Then section 266, which deals with evidence for defense. That is, if the accused wants to read evidence, the accused can read evidence. And here there is only one addition that has been made by way of second proviso, is that the examination of a witness under this subsection may be done by audio, video, electronic means at the designated places to be notified by the state government. This is very important. A recording of evidence in an audio, video, electronic mode cannot be done anywhere. This is where the audio, video recording of evidence will have to be done. So only in such designated places, the court has to record the evidence of the witnesses through audio, video, electronic means. This is the second proviso to which is added. This is that is the proviso. This is the new proviso that has been added as a second proviso to section 266, subsection 1. Then, this is the amendment. These are the amendments so far as Part A is concerned. That is, cases instituted on police report. Cases instituted on police report. Now, cases instituted otherwise than on police report. First, let us see how this mechanism works for the benefit of the youngsters I am talking. A private complaint is filed before the magistrate. Magistrate examines the complainant and the witnesses on oath. That is the recording of verified statement or sworn statement. Magistrate decides to take cognizance of the offence. So case is registered for the offence or offences for which the cognizance has been taken. Summons will be issued to the accused. The accused will appear before the court. It is a warrant trial procedure. Now, what are the materials that are available before the court? Complaint, complaint and the documents, and the examination evidence of the witnesses, that is the statements that have been recorded, These are the only document and also the documents that are available before the magistrate. Summons will be issued, the accused will appear. Copies of all these, that is the copy of the complaint, copy of the list of witnesses, copies of the depositions and all these things will go to the accused along with the summons. Now the accused appears. Now how to frame a charge? In case of charge sheet, there is no problem because a police officer is a public servant. He has conducted investigation. There is a procedure for conducting investigation. There is a procedure for filing charge sheet. There is a procedure for registration of a case. And all these acts are done by a public servant in this cognizance. But in a private complaint procedure, it doesn't happen so. The material that is available before the magistrate court is the private complaint filed along and the statement of witnesses and the complainant recorded under subsection 1 of section 200 or 223 BNSS. Therefore, the procedure that is prescribed in cases instituted otherwise than on police report is, once the accused appears before the court, in a warrant trial procedure, we used to, that is cases instituted on police report, we used to post the case for hearing before charge. After ensuring that the copies have been served. But here, in a private complaint procedure, we are not going to post the case for hearing before charge. We means a magistrate, I am telling. It will be posted for evidence before charge. So the complainant and the witnesses will have to give evidence before the court in support of the allegations made in the complaint. That is called as evidence, not what is recorded in the form of a sworn statement. And that evidence will be recorded as examination in chief. Thereafter, opportunity for cross-examination will have to be given. Of course, accused may cross-examine or may not cross-examine. If it doesn't cross-examine, that cannot be a ground to say that the accused has accepted the guilt, because the evidence is recorded only for the purpose of ascertaining whether there is material to frame charge or not. That's all. So upon consideration of the material that is so placed, if the magistrate is satisfied that there are materials to proceed against the accused, he may proceed to frame charge. At that stage, accused has got right to submit his argument for discharge. So the court has to hear both the complainant as well as the accused on the point of evidence, on the material available in the form of evidence before charge, and the complaint and the documents before coming to the conclusion of framing charge. If the magistrate comes to the conclusion that there is no sufficient grounds to proceed, he can discharge the accused then and there itself. Otherwise, the magistrate will proceed to frame charge. So once the charge is framed, then magistrate will ask the accused, look here, so many witnesses have been examined on the side of the complainant before charge. Whom do you want to cross-examine? Whether you want to cross-examine all the witnesses or any who wants only few witnesses, then it is the duty of the accused to file a memo as to whom all he is going to cross-examine who have already been examined in chief. So the court will have to summon those witnesses again, and the complainant will have to tender them for cross-examination by the accused, and accused will have a right to cross-examine. Thereafter, the complainant can examine any other witnesses if he chooses to do. And they will also be submitted for cross-examination of recording statement under section 313 CRPC. An equivalent provision under BNS is also there of the accused. This is the difference between the cases instituted on police report and the cases instituted otherwise than on police. Now, what is the change here? What is the change that has been effected in this part of cases instituted otherwise than on police report? There is only one change. Of course, this change, though it's only one change, it is of a great significance because, let us say, for example, in a case where the complainant has got himself examined and also examined 4 or 5 witnesses in support of his case. So what is available is only the examination in chief. Thereafter, the charge is framed. Accused is asked to cross-examine those witnesses who have been already examined in chief. Supposing the witnesses doesn't turn up at all, then what is the consequence? That is what has been included by way of subsection 7 to section 269, which was not there in the CRPC. What is this new section? Where despite giving opportunity to the prosecution, and after prosecution means the complainant only, and after taking all reasonable measures under the Sanhita, that is issuing bailable warrant, non-bailable warrant, etc. If the attendance of the prosecution witnesses under subsection 5 and 6 cannot be secured for cross-examination, it shall be deemed, this is important, it shall be deemed that such witness has not been examined for not being available, and the magistrate may close the prosecution evidence for reasons to be recorded in writing and proceed with the case on the basis of the materials available on record. So this is an important change that has been brought in this particular part of warrant trial cases, that is cases instituted otherwise than on police report. So except this, there is no other change in this part and it remains as it is. Then in part C, that is the conclusion of trial also, there is only one change, that is in the form of section 272, which deals with absence of the complainant, because it's a complaint procedure. What should be done if the complainant remains absent? If the complainant remains absent, when the proceedings have been, this is section 272 I am reading. No doubt, section 272 is the replica of section 249 of CRPC, but there is some change, addition has been made. What is that addition? I am going to highlight it. The section reads like this. When the proceedings have been instituted upon a complaint, and on any day fixed for the hearing of the case, the complainant is absent, and the offence may be lawfully compounded. So he must be absent, and offence must be lawfully compounded. And it is not cognizable offence. So 3 requirements. The magistrate may, after giving 30 days time to the complainant to be present, this is an addition. So before dismissing the complaint, the court has to grant 30 days time. It doesn't say court should issue notice to him. Court should grant 30 days time to the complainant to be present, notwithstanding anything contained herein before, at any time before the charge has been framed, discharge the accused. So this is 30 days timeline has been fixed for the complainant to appear before the court. When he did not appear before the court on all the previous hearing dates, in spite of granting sufficient adjournment. This is another important change that has been effected in the form of section 272 BNSS. And the equivalent in CRPC is section 249. Then we will move on to the next chapter. That's all the amendment in this chapter. That is warrant trial procedure. And of course, there is one important difference between the warrant trial procedure and a summons trial procedure. That is, in a warrant trial procedure, before proceeding to sentence the accused, supposing in a warrant trial case, the accused has been held guilty for a particular offense, which is punishable with more than 2 years of imprisonment, he has to be sentenced. All of us know that conviction is different, sentence is different. It is not necessary that every person who is convicted should be sentenced always. There is a provision like section 360 CRPC, equivalent of which is under section 401, where Probation of Offenders Act is not in force. And in Karnataka, we have Probation of Offenders Act, which has to be pressed into service to consider whether the accused should be sent to jail or he can be released on probation of good conduct or good behavior. All those provisions are there. Conviction is different, sentence is different, but conviction is a stigma always. So a person convicted need not always be sent to jail. There are provisions where he need not be even sent to jail, but he can be allowed to remain in the mainstream of the society, subject to certain conditions which the court is going to fix as per the terms of the Probation of Offenders Act. Why I am telling all this is, conviction first has to be passed. Accused has been convicted for the offense under section so and so. But when coming to the question of passing sentence, the law says in a warrant trial procedure, accused has to be heard. So this is one major difference between a summon trial procedure and a warrant trial procedure that you will see when you read section 271, subsection 2, which is equal to section 248, subsection 2 CRPC, which reads as follows. Where in any case, I am talking about warrant trial procedure only, where in any case under this chapter, that is chapter dealing with the warrant trial procedure, the magistrate finds the accused guilty, so he has been convicted, but does not proceed in accordance with the provisions of section 364 or 401. So here in Karnataka, we have Probation of Offenders Act. He shall, the word used is shall, after hearing the accused on the question of sentence, pass sentence upon him according to law. So this is there this was there in CRPC also, and it is now in BNSS also. Therefore, it is mandatory for the magistrate to hear the accused regarding sentence after he has been convicted before passing an order regarding sentence. This is another important difference between the two. Now we will move on to the next chapter, that is trial of summons cases by a magistrate. So once again, to recapitulate ourselves, summons case is a case where the offence is punishable up to 2 years of imprisonment. In a summons trial procedure, there is no stage for hearing before charge earlier. There was no stage for hearing before charge earlier. But now, under BNSS, that stage is also provided. That is by way of a proviso to section 274, which was not there earlier in section 251 CRPC. What does it say? When in a summons case the accused appears or is brought before the magistrate, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. So in a summons case, it has been the practice of not framing charge as we used to frame charge in a warrant trial case. What we are going to frame is a substance of accusation. So a proviso has been added here under BNS to this subsection, which says, provided that if the magistrate considers the accusation as groundless, he shall, after recording the reasons in writing, release the accused, and such release shall have the effect of discharge. So if a charge sheet is filed in respect making allegation against the accused of having committed a offence punishable with less up to 2 years, a summons trial, and on considering the charge sheet and other materials, if the magistrate come to the conclusion that the charges leveled are groundless, then he can release the accused then and there itself, and that release amounts to a discharge. So this new provision has been added, which is applicable in a summons case also. So hereafter in summons cases, it is always a right given to the accused, where he can also make a submission before the court that the materials which are placed before the court are not at all sufficient to prove the offence alleged against him, and therefore he is entitled for an order of discharge. So this is one important change that has been brought out in a summons trial procedure. Then, what happens if in a summons trial procedure the complainant does not appear or the complainant dies? That was in section 249 of the CRPC. That is now reproduced in section 279 of the BNSS. 249 CRPC, 279 BRSS. If the summon has been issued to the complainant and the day appointed for the appearance of the accused any day subsequent to, or any day the complainant does not appear. If the complainant does not appear, the magistrate shall, after giving 30 days time to the complainant to be present, notwithstanding anything herein before contained, acquit the accused, unless for some reasons he thinks it proper to adjourn the hearing of the case to some other date. So this power has been given to the magistrate, provided that where the complainant is represented by an advocate or by an officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. So, under special circumstances, the magistrate may dispense with the presence of the complainant and proceed with the case. So, this is 30 days time has to be given is a new addition found in section 279, which was not there in the corresponding section, that is section 272. Sorry. Yes, 279. Then we will move on to chapter 22. That's all the amendment in that chapter, summons trial procedure. Chapter 22 deals with summary trial. That is equivalent to chapter 21 CRPC, which is from section 260 to section 265 of the CRPC, and the equivalent provision in BNSS is section 283 to section 288. One of the major differences that you can find by reading subsection 1 of section 283 in BNSS vis-a-vis section 260 CRPC is that in CRPC it is stated, notwithstanding anything contained in this code, I am talking about CRPC 260, A, any chief judicial magistrate, B, any metropolitan magistrate, C, any magistrate of the first class specially empowered in this behalf by the High Court. So, under CRPC, the power to try the case summarily was given under law itself to any chief judicial magistrate, CJM. The law itself gives him power to try the case summarily. And metropolitan magistrate. These two magistrates were given power under law itself to try the case summarily, the offences which are mentioned therein. But for a JMFC, judicial magistrate first class, he must have been specifically empowered to try the case summarily by the Honorable High Court. So magistrate could not try the case summarily exercising power under law unless he has been empowered by the High Court. Now, what is the change here? The change here is, I am reading the change section 283. Notwithstanding anything contained in this Sanhita, any chief judicial magistrate, so metropolitan magistrate has gone, because I have already told you, metropolitan area and metropolitan magistrates have been abolished. So there is no metropolitan area, no metropolitan magistrate in terms of the BNSS. Notwithstanding anything contained in this Sanhita, any chief judicial magistrate and magistrate of the first class, now both have got power under this section to try the cases mentioned therein summarily. Then they can try the case summarily. So there is no question of giving any power to judicial magistrate first class by the High Court or by any other authority to try the cases summarily, because JMFC has got power to try the case summarily under section 283 subsection 1 clause B. This is one important change that will have to be noted so far as the summary trial is concerned. The next important change that you find in this chapter is the various offences which could be tried summarily have been enlisted from number 1 to number 8. More importantly, number one is about theft. Number two is about receiving or retaining a stolen property. Number three, about assisting in concealment or disposal of a stolen property. So all the three case sections, all the three offences, or the cases involving all these three offences can be tried summarily. That is there in CRPC also, and it is here in BNSS also. But the difference is, in CRPC, the value of the stolen property was fixed at 2,000 rupees, shall not exceed 2,000. Now that has been enhanced under BNS to 20,000 rupees. Then, in CRPC, in the list of offences, serial number 1 was shown as offences not punishable with death or imprisonment for life or imprisonment for a term exceeding 2 years, meaning thereby offences where the punishment is death or life imprisonment, or where the punishment is more than 2 years, it cannot be. Section has been added in BNS, that is subsection 2, which reads as under. The magistrate may, after giving the accused a reasonable opportunity of being heard, for the reasons to be recorded in writing, try in a summary way all or any of the offences not punishable with death, or imprisonment for life, or imprisonment for a term exceeding 3 years. So there it was exceeding 2 years, now it is exceeding 3 years. So even an offence which is punishable with less than 3 years or up to 3 years can be tried summarily by the magistrate after hearing the accused and the prosecution. This is one another change that has been brought in section 283, chapter 22. Then there is one more change that has been brought here. In CRPs, in BNSS, there is a proviso to subsection 2. Supposing a magistrate, after hearing the prosecution and the accused, comes to the conclusion that a particular offence which is not punishable more than 3 years could be tried summarily, and an order is also passed, whether that order can be challenged before the higher court. So the proviso says no. It says, like, provided that no appeal shall lie against the decision of a magistrate to try a case in a summary way under this subsection, that is subsection 2. I am not touching plea bargaining. Chapter 24, attendance of persons confined or detained in prison. No major changes. Chapter 25, evidence in inquiries and trial. So here, evidence can be recorded even through audio, video, electronic means at the designated places to be notified by the state government. That has been added. Now, let us visualize a situation. The accused is in custody and he is examined. That is, evidence is being recorded through electronic communication. He is not physically present before the court, but through electronic communication. How to authenticate it? Accused is in custody. Magistrate is in the designated place from where video conferencing could be done. Evidence is being recorded in an audio, video, electronic mode. Then how to obtain the signature of the accused? To come out of such a situation, subsection 4 has been added in section 316 BNSS, which says that, I am reading, provided that where the accused is in custody and is examined through electronic communication, His signature shall be obtained within 72 hours. There is no major changes in rest of the sections. Yes. With regard to, sir, you have anything to say, sir? Mr. Gautam Chand, sir?
No, sir. No, sir. Only thing is, just you said nothing else. There is no change. That's why I just unmuted myself. That's it, sir.
Okay. Can I proceed?
Yes, sir. Please, sir.
Yes. Section 336. Before that, Section 330 BNSS deals with no formal proof of certain documents. Where any document is filed before any court by prosecution or the accused, the particulars of every document shall be included in the list and the list. If any shall be shall be included in the list, and the prosecution or the accused or the advocate for the prosecution of or the accused, if any, shall be called upon to admit or deny the genuineness of such documents soon after the supply of such documents, and in no case later than 30 days. So this refers to reports of certain government and scientific experts. So if the prosecution or the accused wants to produce any document, and if those documents are produced, at the time of, along with the documents so produced, the prosecution or the accused, whoever it is, they have to prepare a list, mention the names of the documents that they are going to produce, and call upon the other side, each other, whether they are going to admit or deny. This is what Section 330 of BNSS says. So here the only amendment is soon after the supply of such documents, and in no case later than 30 days after supply. So that time limit is prescribed for the accused or the prosecution to say whether they are going to admit or deny that particular document. And there is a second proviso which is newly added. No expert shall be called to appear before the court unless the report of such expert is disputed by any of the parties to the trial. So when the documents are of the nature mentioned in section 329 or 328 BNSS, they can be accepted by the court without any formal proof. If at all any party to the case, either the prosecution or the accused, deny that, then only he can be called for, the expert can be called for cross-examination. Otherwise, he need not be called. So the document can be accepted as they are without any formal proof. This is also an amendment that has been brought. Then coming to section 335, record of evidence in the absence of the accused. Evidence of public servants, experts, police officers in certain cases. This is section 336. Very important section it is. Because sometimes it so happen, a court will issue summons to a doctor who has done postmortem examination. Doctor is either transferred or dead, or he is not available and his whereabouts are not known. As a result, the document will go unmarked, unproved. Or some public servant is required is a material witness to a case, and summons will be issued to him to appear before the court and speak on the basis of a particular record. And even he is not available because either he is transferred or dead or is not available. Then what should happen in such cases? Can those documents go without being proved? This is the question for which we have to find answer. I think that answer is found in section 336. It says like this. This is a new section where any document or report prepared by a public servant, scientific expert, or medical officer is purported to be used as evidence in any inquiry, trial, or other proceedings under this Sanhita. Number one, such public servant, expert, or officer is either transferred, retired, or dead. Number two, or such public servant, expert, or officer cannot be found or is incapable of giving evidence. Number three, or securing presence of such public servant, expert, or officer is likely to cause delay in holding the inquiry, trial, or other proceedings. So in all these three circumstances, it is practically not possible to get that public servant, expert, or the officer. Then what should happen? The court shall secure the presence of the successor in office of such public servant, expert, or officer who is holding that post at the time of such deposition to give deposition on such document or report. Probably because, after all, the evidence will have to be given on the basis of the record. So the person who was present at the time of preparing the record and who has actually a material witness to speak with regard to that particular document or record may not be available for the reasons which I have stated. Under such circumstances, a person who is a successor in office can be summoned and his evidence can be recorded in relation to that particular document or report. This is in section 336. For that, there is a proviso, provided that no public servant, scientific expert, or medical officer shall be called to appear before the court unless the report of such public servant, scientific expert, or medical officer is disputed by any of the parties of the trial, at the trial or other proceeding. This is very important. ಯಾವುದಕ್ಕೂ ಕರೆಸ್ಬಿಡಿ ಸ್ವಾಮಿ ಇರ್ಲಿ ಅಂತ ಒಂದು ಸಾಮಾನ್ಯವಾಗಿ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಕ್ಯೂಸ್ಡ್ ಹೇಳ್ಬಿಡ್ತಾರೆ. ಬಟ್ ಆ ಪಾಪ ವಿಟ್ನೆಸ್ ಅವರೆಲ್ಲೋ ಇರ್ತಾರೆ, ಡೆಲ್ಲಿನಲ್ಲೋ ಬಾಂಬೆನಲ್ಲೋ ಇರ್ತಾರೆ. He is not disputing the PM report, but he wants the witness to come all the way from the place. Where is the need? Why he should come at the cost of the government? Taxpayers' money. Therefore, the section says, unless the party disputes that particular document or denies that particular document, then such government servant, public officer, expert, medical officer need not be secured. So that is another thing. So if the document is admitted, it can be taken as it is, provided further that deposition of such successor public servant, expert, or officer may be allowed even through audio video conference. So let the public servant be in Delhi itself. We can have an audio video conference from Bangalore through a designated place, from a designated place. This is another important aspect to be kept in mind. Then section 346 subsection 2, which deals with power to postpone or adjourn proceedings. Here, the section mandatorily says under clause A in the fourth proviso that not more than 2 adjournments may be granted in a case after hearing the objections of the other party. That is another thing. And section 349 says, magistrate has got power for the reasons to be recorded in writing, order any person to give specimen signature or voice sample without him being arrested. Then section 356. Inquiry, trial, and judgment in absentia of the proclaimed offender. So this says that the judgment can be pronounced even in the absence of the accused. Then another important section, withdrawal from prosecution. A prosecutor will make an application before the court seeking permission of the court to withdraw from the prosecution. As all of us know that Merely because the prosecution makes an application, the court is not obliged to allow it. The court has to go into the matter and find out whether it is proper to allow the application or there is a separate section, section 321 CRPC, and the equivalent section is also found in the form of section 360 BNSS. Here what they say is, when an application is filed by the prosecution seeking permission to withdraw, the victim also should be heard. This is a very, very important change that has been brought out in this particular section. So victim also will have to be heard on the point of the permissions that the prosecution is seeking to withdraw. No court shall allow such withdrawal without giving an opportunity of being heard to the victim in the case. And of course, subsection 2 says of section 366 that all sexual offences matters and POCSO cases will have to be conducted in camera. Then chapter 27 is not amended. The entire chapter is as it is. Chapter 28 is also not amended, except small amendments with regard to the fine component and not other things. And the chapter 29 deals with judgment, which says that the judgment will have to be delivered within days. And the judgment so delivered will have to be uploaded into accused who is in custody, if his product production is
Sir, your voice is breaking.
section 330, no amendment. Chapter 31, no major amendments. Chapter 32, reference and revision, no amendment. Chapter 23, 33, transfer of criminal cases, no amendment. And now the other chapters which are remaining are which regard to the provisions regard.
Sir, your voice is breaking, sir. There is some internet this thing issue, network issue, sir.
This is my request. Sir.
Sir, you are
sir, some internet
Sir,
connectivity.
Can we
now we can hear you, sir.
Sir, can we? I have 3 more parts to complete with regard to bail bonds and the forfeiture, limitation, and disposal of property. Shall we close at this or shall we continue, sir? It will take another half.
Sir, summarily you can conclude, sir.
Allah, summarily conclude madakagala bidi. We will close at this. So I think with this we can close it for the day.
Yes, sir.
Thank you, sir, for discussing the nuances of the newly implemented law. Now the forum is open for the question answer session. Kindly requesting all the participants to send across your questions in the chat box. I request Mr. Mallikarjun, sir, to pose the questions before the speaker.
So we can close it, no? Hello?
Sir, question and answer session,
Yes,
sir.
Can we close it?
Question and answer
Sir,
session,
question
sir.
and answer session ಪ್ರಾರಂಭ ಆಗ್ತಾ ಇದೆ ಸರ್.
ಅದು ಇನ್ನು 4 ಪಾರ್ಟ್ ಉಳ್ಕೊ ಇನ್ನು 4 ಸ್ಮಾಲ್ ಪಾರ್ಟ್ಸ್ ಉಳ್ಕೊಂಡಿದೆ.
ಅದನ್ನ ನಂತರ ಮಾಡೋಣ ಸರ್.
ಲಿಮಿಟೇಷನ್ ಅದು
Next week ನಲ್ಲಿ ಮಾಡೋಣ ಸರ್.
ಆಮೇಲೆ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಅದೆಲ್ಲ ಆಮೇಲೆ ಮಾಡೋಣ.
Very good evening, sir. Sir, today we have few questions. The main question is, does this BNSS section 223, that means in respect of taking cognizance when a private complaint is filed, does it apply to negotiable instrument act cases?
For every criminal case, it applies. It applies to every criminal case.
Yes, sir.
Every
And the second
offense.
question, yes, sir. And the second question is that, sir, any application made before a magistrate, if the case is to be tried by a court of session, then the command is that all the applications shall be forwarded to the concerned sessions court. Now, the question is, even the release of property, if it is moved by the victim or the accused, which generally used to move under 451, 457, even these applications should also be forwarded. Do you mean to say that the magistrate power has been taken away or not? Sir, hope you got my question, sir. So there is some technical glitches, sir, over here.
Taking this question.
Sir.
Hello. Am I
Yes,
audible?
sir. Yes, sir. Yes, sir. Please, sir.
Yes. Before taking this question, in continuation of the answer which I have given for the previous questions as regard the chapter relating to cognizance will have to be looked into, because under different enactment, the procedure for procedure is the same, but under what are the steps for taking cognizance will be prescribed in the different enactments. For example, so therefore, procedure is the same. Procedure is what is mentioned in section 223. But for the purpose of taking cognizance, when the question of proper compliance arises, then we will have to go to the relevant enactments with which we are dealing. So that is one important aspect which I want to add.
Yes,
Insofar as the second question is concerned, your
Yes,
question was whether the application with regard to disposal of property either filed by the accused or by the victim also will have to be forwarded to the sessions court. That is your question. For
Yes,
this,
sir.
my answer at this stage is, I don't say because the section does not differentiate that application or this application. That's the section only says any application filed either by the accused or the victim will have to be transferred to the sessions court along with the committal records. So whether that application includes or does not include, that time only should say, and the interpretation of the section does not distinguish between them. That's all what I can say.
Yes, sir. So next question is that, is there a difference between the provision 1, the provision of 254(1) and section 254 clause 2?
Of
254,
yes.
sir. BNSS. Section 254 of BNSS. The provision of subsection 1 of 254 and subsection 2 of 254.
Are they correct? Section 1 is a general section. We can take it as also. So it could be recorded either physically or through audio, video, electronic means. Subsection 2 says deposition of evidence of any public servant may be taken through audio, video, electronic means. Again, that is the word used is may. For example, let us say the prosecution wants to summon a witness from Bombay. Then the court may say, why do you want to summon that public servant from Bombay all the way by spending money and all that of the government at the taxpayers' cost? Arrange for a video. We will arrange for a video conference. So the court may suggest to the prosecution and also to the accused to have evidence recorded through video conference through designated place from designated places.
Yes, sir. So these are the questions for the day, sir. Thank you, sir. Now I request Sankirtana to take over.
Thank you, sir. Now I request our president, Shri Gautam Chand sir, to share his thoughts on the series.
Sir, we are extremely thankful and we express our sincere gratitude on behalf of Karnataka State Bar Council and Karnataka State Bar Council Law Academy. In fact, we are very fortunate enough that a so experienced judge who has handled civil and criminal extensively has spared his time so much for educating the students and young advocates with respect to new enactment wherein we have not yet got case laws. We are extremely thankful and I sincerely extend my gratitude, sir. Thank you very much. Now I move on to Harish, who shall address a formal vote of thanks. Mr. Harish, please.
Namaste, Shubha Sanjay. Karnataka Rajya Vakilra Parishattu Law Academy ವತಿಯಿಂದ ಆಯೋಜಿಸಲಾಗಿರ್ತಕ್ಕಂಥ ಈ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆ ಭಾರತೀಯ ನಾಗರಿಕ ಸುರಕ್ಷಾ ಅಧಿನಿಯಮ ದಿನಾಂಕ 16ರಿಂದ 19ರವರೆಗೆ ಬಹಳ ಅದ್ಭುತವಾಗಿ ಮೂಡಿ ಬಂದಿದೆ. ಕಾರಣ ಲಾ ಅಕಾಡೆಮಿಯ ಚೇರ್ಮನ್ರು ಬಹಳ ಕಷ್ಟಪಟ್ಟು ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿರ್ತಕ್ಕಂತಹ ವಕೀಲರುಗಳಿಗೆ ವಕೀಲರ ಪರಿಷತ್ತು ಯಾವಾಗಲೂ ಸದಾ ಇರುತ್ತೆ ಅಂತ ಹೇಳಿ ಒಂದು ತೋರಿಸ್ಲಿಕ್ಕೆ ಮತ್ ನಾವಿದ್ದೇವೆ ಕೆಲಸವನ್ನು ಮಾಡ್ತಿದ್ದೇವೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನ ಬಹಳ ಅಚ್ಚುಕಟ್ಟಾಗಿ ಮಾಡ್ತಾ ಬಂದಿದೆ. ಅದರ ಭಾಗವಾಗಿ ಶ್ರೀಯುತ DR ಸುದರ್ಶನ್ ಸಾಹೇಬ್ರು ದೊಡ್ಡಬಳ್ಳಾಪುರದವರು. ದೊಡ್ಡಬಳ್ಳಾಪುರ ಅಂದಿದ ತಕ್ಷಣ ನಮ್ಗೆ ಜ್ಞಾಪಕ ಬರ್ತಕ್ಕಂಥದ್ದು ಶ್ರೀಯುತ ದಿವಂಗತ T ಸಿದ್ಲಿಂಗಯ್ಯ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆಂಟ್ ಅಸೆಂಬ್ಲಿಯ ಸದಸ್ಯರಾಗಿರ್ತಕ್ಕಂಥವ್ರು. ಭಾರತೀಯ ಕಾಂಗ್ರೆಸ್ನ ಮೊದಲ ಅಧ್ಯಕ್ಷರು ಮೈಸೂರು ರಾಜ್ಯದ್ದು. ನಂತರ ಪ್ರಥಮ ಜನಪ್ರತಿನಿಧಿ ದೊಡ್ಡಬಳ್ಳಾಪುರದಿಂದ. ಇಂತಹ ದೊಡ್ಡಂತವ್ರು ಆರುಡಿ ರಾಮಚಂದ್ರಯ್ಯನವರು, ಆರುಡಿ ನಾಗರಾಜನ್ ಅವರು, ನಮ್ಮ ಜಸ್ಟಿಸ್ BK ಸೋಮಶೇಖರ್ ಅವರ ಫಾದರ್ ನಾರಾಯಣ ಅಯ್ಯಂಗಾರ್ ಅವರು, BK ಕೃಷ್ಣಮೂರ್ತಿ ಅವರು, ಜಸ್ಟಿಸ್ BN ಕೃಷ್ಣನ್ ಅವರ ಫಾದರ್ ನಾರಾಯಣ ಅಯ್ಯಂಗಾರ್ ಅವರು, ಇವರೆಲ್ಲರೂ ಸಹ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿರ್ತಕ್ಕಂಥ ದೊಡ್ಡಬಳ್ಳಾಪುರ ಸಬ್ ಡಿವಿಷನಲ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್. ನಮ್ಮ D ಕೃಷ್ಣಪ್ಪನವರು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಇದ್ರು. CH ಹನುಮಂತರಾಯರವರು ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಕೆಲವು ಸಮಯದಲ್ಲಿ ಮಾತ್ರ ಹೋಗ್ತಾರೆ. ಅವ್ರು ಬೆಂಗಳೂರಿನಲ್ಲೇ ಇದ್ದಾರೆ. ಖ್ಯಾತ ಕ್ರಿಮಿನಲ್ ಸೈಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡುವಂತಹ ವಕೀಲರು. ಅವರ ಸಾಲಿನಲ್ಲಿ ಶ್ರೀಯುತ DR ಸುದರ್ಶನ್ ಅವರು. ನಾನು ಇವತ್ತು ದೊಡ್ಡಬಳ್ಳಾಪುರಕ್ಕೆ ಹೋಗಿದ್ದೆ ಯಾವುದೋ ಕೇಸ್ನಲ್ಲಿ. ಈ ವಿಚಾರವಾಗಿ ಮಾತಾಡ್ತಾ ಹೇಳಿದ್ರು, DR ಸುದರ್ಶನ್ ಅವರು ಆದಿನಾರಾಯಣ ರಾವ್ ಅವ್ರ ಹತ್ರ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ದೊಡ್ಡಬಳ್ಳಾಪುರಕ್ಕೆ ಪ್ರಾಕ್ಟೀಸಿಗೆ ಬಂದಾಗ ಅವರ ಜ್ಞಾಪಕ ಶಕ್ತಿ ಎಷ್ಟಿದೆ ಅಂದ್ರೆ, ಇವತ್ತು ಒಂದು ಇಂಜಂಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ 39 ರೂಲ್ 1 and 2 ಅದ್ರ ಕಂಟೆಂಟ್ಸ್ ಅನ್ನ ತಲೆನಲ್ಲೇ ಎತ್ಕೊಂಡು ಹೇಳ್ಬಿಡ್ತಾರೆ. ನಾವು ಬುಕ್ ಓದ್ಬೇಕು, ವಾಟ್ ಈಸ್ ಆರ್ಡರ್ 39 ರೂಲ್ 1 and 2 ಅಂತ. ಅಷ್ಟು ಜ್ಞಾಪಶಕ್ತಿ ಇರ್ತಕ್ಕಂಥವ್ರು ಶ್ರೀಯುತ DR ಸುದರ್ಶನ್. ಅವರನ್ನ ಲಾ ಅಕಾಡೆಮಿ, ನಮ್ಮ ಕೋಟೇಶ್ವರ ಅವರು ನಮ್ಮ ಮೆಂಬರ್ಸು ಇಲ್ಲ, ಅವ್ರನ್ನ ಭಾರತೀಯ ನಾಗರಿಕ ಸುರಕ್ಷಾ ಅಧಿನಿಯಮವನ್ನ ಅವ್ರ ಕೈನಲ್ಲೇ ಪಾಠ ಮಾಡಿಸ್ಬೇಕು ಅಂತೇಳಿ ಅವರು ಸಿವಿಲ್ ಜಡ್ಜ್ ಎಕ್ಸಾಮಿನೇಷನ್ ತಗೊಂಡಾಗ ಆ ಗ್ರೂಪ್ ನಲ್ಲಿ ಮೊದಲನೇದಾಗಿ ಬಂದಿದ್ರು ಅಂತ ನನ್ನ ಗಮನಕ್ಕಿದೆ. ಅಂತಹ ಮೇಧಾವಿಗಳು ಆದಷ್ಟು ತಕ್ಕ ಮಟ್ಟಿಗೆ ಆನ್ಲೈನ್ ನಲ್ಲಿ ನಮಗೆ ಇಡೀ ಕರ್ನಾಟಕಕ್ಕೆ ನಮ್ಗೆ ಈ ವಿಡಿಯೋ ಈಗ ನಂತರ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಅವೈಲೇಬಲ್ ಇದೆ. ಈ ತರದನ್ನ ಕರೆಸಿ ಅವರನ್ನ ನಾವು ಅದ್ಭುತವಾಗಿ ಅವರು ಈ ಅಧಿನಿಯಮವನ್ನ ವಿಚ್ ಓವರ್ಲ್ಯಾಪ್ಸ್ ದಿಸ್ CRPC ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಲಾ ಅಕಾಡೆಮಿ ವತಿಯಿಂದ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾದ ವಂದನೆಗಳು. ನೀವು ಯಾವಾಗ್ಲೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಜೊತೆ ಇರ್ಬೇಕು, ನಾವ್ ಯಾವಾಗ ಕರೆದ್ರು ಬರ್ತೀರಿ ಅಂತ ನಾನು ಅನ್ಕೊಂಡು ನನ್ನ ಹೃತ್ಪೂರ್ವಕ ವಂದನೆಗಳನ್ನ ನಿಮ್ಗೆ ಅರ್ಪಿಸ್ತೇನೆ ಸರ್. ಅದೇ ರೀತಿ ಕಾರ್ಯಕ್ರಮವನ್ನ ಆಯೋಜಿಸ್ಲಿಕ್ಕೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರು, ಉಪಾಧ್ಯಕ್ಷರು ಎಲ್ಲ ಮೆಂಬರ್ಸು ಕೈ ಜೋಡಿಸಿದ್ದಾರೆ. ಅವ್ರಿಗೂ ಸಹ ನಾನು ವಕೀಲರ ಪರಿಷತ್ತಿನ ಸದಸ್ಯನಾಗಿ ನನ್ನ ವೈಯಕ್ತಿಕವಾಗಿ ಮತ್ತು ವಕೀಲರ ಪರಿಷತ್ತಿನ ಮೂಲಕ ವಂದನೆಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಈಗ ನಮ್ಮ ಇದರಲ್ಲಿ ಏನು ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕೋಟೇಶ್ವರ ಅವರಿದ್ದಾರೆ, ಮಧುಸೂದನ್ ಅವರಿದ್ದಾರೆ, ನಮ್ಮ ಬಾರ್ ಕೌನ್ಸಿಲಿನ ಮೆಂಬರ್ಸು, ಅವ್ರಿಗೂ ಸಹ ನಾನು ವಂದನೆಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಇದ್ರ ಜೊತೆಗೆ ಈ ಕಾರ್ಯಕ್ರಮ ಸಕ್ಸಸ್ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ವ್ಯೂವರ್ಸ್ ಇರ್ಬೇಕು. ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ವ್ಯೂವರ್ಸ್ ಇದ್ದೀರಿ. ಮೊದಲನೇ ದಿವಸ ಅಂತೂ ಸಾಕಷ್ಟು 250 ಸಂಖ್ಯೆಗಿಂತ ಹೆಚ್ಚಿತ್ತು. ಹಾಗಾಗಿ ಎಲ್ರು ಕರ್ನಾಟಕ ರಾಜ್ಯದ, ಈಗ ನಾನು ಬೀದರ್ನ ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ನಮ್ಮ ಪರಮೇಶ್ವರ್ ಪೊಂಬುಲಿಂಗೆ ಇದ್ರು, ಅನೇಕ ಭಾಗಗಳಿಂದ ಇದ್ರಲ್ಲಿ ನಾನು ನೋಡ್ತಾ ಇದ್ದೇನೆ. ಹಾಗಾಗಿ ಎಲ್ರಿಗೂ ಸಹ ಅನಂತ ಧನ್ಯವಾದಗಳು. ನೀವೆಲ್ಲರೂ ನಮಗ್ ಸ್ಫೂರ್ತಿ. ಬಾರ್ ಕೌನ್ಸಿಲ್ ಕಾರ್ಯಕ್ರಮ ಮಾಡ್ತಾ ಇದೆ, ಬಾರ್ ಕೌನ್ಸಿಲಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸ್ತಾ ಇದ್ದೀರಿ, ಜ್ಞಾನಾರ್ಜನೆಯನ್ನ ಪಡೆದುಕೊಂತ ಇದ್ದೀರಿ. ಎಲ್ರಿಗೂ ಸಹ ನಾನು ವಂದನೆಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ನಮ್ಮ ಅಧ್ಯಕ್ಷರು, ಲಾ ಅಕಾಡೆಮಿ ಅಧ್ಯಕ್ಷರು ಗೌತಮ್ ಚಂದ್ ಅವರು ಮತ್ತು ಅವ್ರ ಸ್ಟಾಫ್ ಆಫೀಸ್ನಿಂದ ಅವರು ಎಲ್ಲರನ್ನ ಸಜ್ಜುಗೊಳಿಸಿದ್ದಾರೆ. ಲಾ ಅಕಾಡೆಮಿ ಚೇರ್ಮನ್ ಆದ್ಮೇಲ್ಗಡೆ ನೋಡಿ, ನಾನು ಲಾ ಅಕಾಡೆಮಿಯನ್ನ ಯಾವ ರೀತಿಯಾಗಿ ಸಜ್ಜುಗೊಳಿಸಿ ಕೆಲಸ ಮಾಡ್ತೇನೆ ಅಂತೇಳಿ ತಮ್ಮದೇ ಆದಂತ ಶೈಲಿನಲ್ಲಿ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಯೋಜಿಸಿದ್ದಾರೆ. ಶ್ರೀಯುತ ಗೌತಮ್ ಚಂದ್ಜಿ ಹಾಗೂ ಅವರ ಸ್ಟಾಫ್ ಈಗೇನು ಯಾರ್ಯಾರು ಇದ್ದಾರೆ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ಇರ್ಬೋದು, ಮೇಡಮ್ ಐ ಫಾರ್ಗಾಟನ್ ಅವರ್ ನೇಮ್ ಇರ್ಬೋದು, ಎಲ್ರಿಗೂ ಸಹ ಆಭಾರಿಯಾಗಿದ್ದೇನೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಈಗೇನು ನ್ಯಾಯ ಸಂಹಿತೆ ನಾಗರಿಕ ಸುರಕ್ಷಾ ಸಂಹಿತೆ ಅರ್ಧಕ್ಕೆ ನಿಂತಿದೆ, ಅದನ್ನ ಸುದರ್ಶನ್ ಸಾಹೇಬ್ರಲ್ಲಿ ನಾನು ಕೇಳ್ಕೊಳ್ಳೋದೇನಂದ್ರೆ, ಇದನ್ನ ವಿ ವಿಲ್ ಕಂಟಿನ್ಯೂ. ಆಗ್ಲೇ ಮೆಸೇಜ್ ಹಾಕಿದ್ದಾರೆ ಯಾರೋ, ಇದನ್ನ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು ಅಂತ. ಓಕೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಯಮಾಡಿ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೇವೆ. ಇದೊಂದೇ ಅಲ್ಲ, ಇಡೀ ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಮೂಲೆ ಮೂಲೆಗಳಲ್ಲಿ ನಮ್ಗೆ ಇವತ್ತು ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ಸಿಕ್ಕೋದ್ ಕಷ್ಟ ಆಗಿದೆ. ಎಲ್ಲಾ ಕಡೆ ಈಗ ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲೆಯಲ್ಲಿ ಪ್ರಾರಂಭ ಆಗ್ತಾ ಇದೆ, ಬೀದರ್ ಜಿಲ್ಲೆಯಲ್ಲಿ ಪ್ರಾರಂಭ ಆಗ್ತಾ ಇದೆ, ಗುಲ್ಬರ್ಗಾದಲ್ಲಿ ಪ್ರಾರಂಭ ಆಗ್ತಾ ಇದೆ. ಎಲ್ಲ ತಾಲೂಕುಗಳಲ್ಲೂ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್ಸ್ ನಲ್ಲೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಈ ಹೊಸ ಕಾನೂನುಗಳ ಬಗ್ಗೆ ನ್ಯಾಯದಾನವನ್ನ ಮತ್ತು ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಆಯೋಜಿಸ್ತಾ ಇದೆ. ಅದಕ್ಕೆ ಎಲ್ರಿಗೂ ಧನ್ಯವಾದಗಳು. ನಮಸ್ಕಾರ, ಶುಭ ಸಂಜೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಜೊತೆ ಎಲ್ಲರೂ ಕೈ ಜೋಡಿಸ್ಬೇಕು, ಇನ್ನು ಹೆಚ್ಚಿನ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಅನುವು ಮಾಡಿಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ನನ್ನ ಮಾತುಗಳಿಗೆ ವಿರಾಮ ಹೇಳ್ತೇನೆ. ಜೈ ಹಿಂದ್, ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ ಎಲ್ರಿಗೂ. ಥ್ಯಾಂಕ್ಸ್. ವಿಶೇಷವಾಗಿ ಜಡ್ ಸಾಹೇಬ್ರು, ಗುರುಗಳು ವೆಂಕಟ್ ಸುದರ್ಶನ್ ಸರ್ ಅವರಿಗೆ ಮತ್ತೊಮ್ಮೆ ವಕೀಲ ಪರಿಷತ್ತಿನ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳು. ಇಡೀ ರಾಜ್ಯದ ವಕೀಲರ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳು. ನಮಸ್ಕಾರ. ಥ್ಯಾಂಕ್ ಯು. ಲೆಟ್ ಅಸ್ ಕನ್ಕ್ಲೂಡ್. ಥ್ಯಾಂಕ್ ಯು.
Thank you everyone. I would like to just give a concluding note. We thank our esteemed speaker, retired Honorable Justice Venkata Sudarshan sir, for spending his precious time with us throughout the week and enlightening us about the new procedural law. We are very, very grateful to have you, sir, as our esteemed speaker for the lecture series. Thank you so much. This academic initiative was a week-long continuous lecture series. This lecture series began on Monday and it ends today. But as per the request, it will continue again. This event was organized under the able leadership of Sri Gautam Chand Sir, President, KSBC Law Academy. I thank him wholeheartedly for giving us all this great opportunity. I would also like to thank all the individuals who have worked in the background tirelessly to make this series a huge success. Thanks to everyone. We certainly hope that this lecture series has helped you understand the nascent law better. All the recordings of the sessions can be accessed on the KSBC Law Academy's YouTube channel. We hope to see you again, all the participants in the upcoming events. Thank you one and all for attending the lecture series. Thank you.
Thank you, Sankirtana.
Thank you.
Thank you. Let us conclude.
Sankirtana, I forgot her name.
Yes, thank you.
I close the session.
Yes, thank you.